Council on Bard College versus Dutchess County Board of Elections. Please come up. You may proceed, Council.
Thank you, Your Honor. May it please the court. There is only one.
You represent?
I represent Appellant Election Commissioner Eric Haight. Your Honors, there is only one point in time where the determination at issue could have been made, and that is the noticed public meeting that was held on February 25th, 2021. The entire premise of holding that meeting in order to make polling place designations was to comply with the open meetings law, which by its terms requires that governmental decision-making take place at a noticed public meeting where members of the public
So can I ask you a question? I have a few housekeeping details. One is, in the verified answer, the respondent argues that you neither have the capacity or the standing to bring this appeal. What's your response?
We do have the standing and the capacity to bring the appeal because we've been named separately as a respondent in this case. There's a split between the election commissioners with the result that the county attorney or the county attorney's office has recused itself, and quite simply, this is apples and oranges from a situation where one election commissioner is commencing an action unilaterally and trying to effectively represent the Board of Elections as one person. Here, the entire premise is we have the election commissioners split. The fact that one election commissioner disagrees doesn't mean that the other election commissioner becomes unable to defend themselves or put the position that they think should be asserted before the court.
So would you agree with me that, just getting by the standing and capacity issues, that the Commissioner Black and Haight, I'm not sure if I'm pronouncing that correctly, failed to reach an agreement on the particular polling places by the statutory deadline of March 15th, 2021?
It's Haight. No, I definitely would not agree with that because polling places were designated.
Did they reach an agreement? Did the two of them reach an agreement?
Did the two of them reach an agreement? I'm not trying to evade your question.
Okay.
The established practice of the Board of Elections.
No, but I'm not even there yet. Did they agree?
They did not agree to change the polling place for 5 locations.
So the question is, when did the board's action become final?
So the established practice of the Board of Elections is that when the election commissioners do not agree, the polling place designation does not change. At the time they made the 2020 designation.
I know that you want to say certain things, but I'm trying to go through it. I'm not as young as I used to be. I have to do it as a progression. So answer the questions that I'm asking. So the question is, when did the board's action become final?
February 25th, 2021.
And how could that be so? Well, let me ask you another question. Does the action of the board require a majority vote, and that the only way the board could act is by unanimous vote of the 2 commissioners, which did not happen, right?
Well, yes and no. There was unanimous consent to hold the polling place meeting and to close it when it was done. The customs and practices of the Board of Election are established. So by definition, they did not agree on changing those 5 polling places. So in accordance with the established practice, the polling places did not change. And at the conclusion of the meeting, the polling places that had not changed were back at their 2019 defaults. At that moment in time, someone who felt that they were aggrieved by the failure to change a polling place designation would have been able to go to the Supreme Court and commence an Article 78 proceeding.
Suppose that they had come to an agreement, the 2 commissioners. They had come to a compromise. Are you suggesting that they could not then change and decide and come up with a compromise if they had not gone past the March 15th date? Is that your suggestion?
I'm not certain I understand the question right, but Election Law 4104 provides that after the Board of Elections has designated polling places.
I know that
sent
you
out
want to tell
cards.
me that 5 times already, and I understand that. The question that I'm asking you is whether or not, if the two commissioners had come to an agreement, could they have designated a poll prior to the March 15th date?
You mean other than at the February 25 meeting?
Yes.
Well, I believe based on the open meetings law premise I just recited, they would have needed to notice another public meeting, but 4104 explicitly allows the Board of Elections to change a designated polling place if it's determined to be unsuitable or unsafe. If that takes place after the voter cards have been sent out, which is the case here, then 4104 provides procedures that need to be followed to send out new notices to the voters.
So begrudgingly, you said maybe they could. So by what point would it be absolutely clear that the board would not be making a designation?
On February 25th, the board declined to change the designation for 5 polling places, including Election District 5. At that point, it was clear. However, after the designations had been made, the board could have at any time determined that a designation had become unsuitable or unsafe and have changed it in the manner provided in Section 4104.
So would you explain to the bench why you believe there's sufficient evidence to justify reverting to the 2019 designations?
Well, preliminarily, one issue here is that my client was not afforded the ability to answer and submit briefs that address things on the merits, but the evidence that's in the record is, first and foremost, the video covering the proceeding. Second, affirmations that quote from that video. Third, an affidavit from Commissioner Black, which talks about the agreement to default to 2019, but suggests it applied only in certain circumstances. And then finally, a reply affidavit from my client stating that the agreement to default to 2019 applied across the board and that no one had challenged any of the other default locations.
So can you point to any evidence in the record during the hearing on February 25th where either the commissioner explained why they were departing from the undisputed policy of defaulting back only to the immediately prior year's designation?
At the beginning of the meeting, the election commissioners discussed that and agreed it and used that rationale.
Can you tell me precisely what he said?
I can't tell you from memory precisely what he said. I would have to refer you to the video. Although I believe in the affirmation that we submitted, this was a portion of the video that was quoted from.
So the rule is that an agency cannot simply depart from its prior policy by simply disregarding the rules on the books. You agree with me?
As a general proposition, sure.
Okay, so you argue that no designation took place in 2020. How could that be accurate?
No, there was a designation that took place in 2020, which was the St. John's Church designation. Then there was litigation with the result that shortly before—
I was on that bench, so I'm fully familiar with the litigation. So there was a designation in 2020.
Elections took place in 2020 and there were designated polling places.
So why wouldn't you revert back, as is your policy, to 2020?
Because the actual policy that was adopted in 2020 when these changes were being made was that the board would default back to 2019 because by and large, the polling place designations were being changed because of COVID-19 concerns, not because of concerns that would be ongoing into the future.
The policy you have in place is, according to the election law, 32122, is if there's an emergency, then you don't revert back to the year before? What's written there? What's the policy?
Well, this entire policy is, to my knowledge, not written. It's simply the result of the fact that the board needs to proceed by majority action. So if you have a 1-1 vote on what a new polling place should be, how else is the issue supposed to be resolved?
Let me ask you a question. Parting from the premise that my colleague has concluded the line of inquiry. Rana, yes? Thank you. policy, quote unquote, denotations, connotations. You've stated that the policy is X. Would your colleagues on the respondent side be in agreement?
Okay, well, first of all,
No, not okay. Wow. It's, will your colleagues on the respondent side be in agreement with what you stated is the definitional parameter of the policy? Just a simple yes, no, or you don't understand my question.
I actually didn't understand the question, but
Fair enough.
because I didn't.
Fair enough. What else you got before you run out of time?
Okay, so what's in the record that reflects the existence of this policy is, first of all, the video where they conducted the meeting and used this policy to make 4 other polling place designations, which have not been disputed, and to which voting equipment is right now being deployed. Aside from that, like I said, there are affidavits, an affidavit from Commissioner Black that makes reference to it, but suggests it was somewhat limited, and an affidavit from Commissioner Haight that says the agreement to default to 2019 was not so limited. A key issue here is, even if we get beyond the statute of limitation, what makes the decision to default back to 2019 arbitrary and capricious? And for that matter, if all of the other unagreed polling places are defaulting to 2019, why is it not arbitrary and capricious to single one polling place out to be treated differently? I mean, one thing that never comes out from what's said in the decision below is whether it was arbitrary and capricious to go back to the 2019 baseline, or whether it was arbitrary and capricious to go back to the 2019 baseline for this polling place, but that it was not arbitrary and capricious to default to that baseline for the other polling sites. In many respects, the situation as it stands now illustrates precisely why the statute of limitations is important, because had this case been commenced 20 days earlier, it would presumably be 20 days earlier right now that I was standing before you, rather than 3 business days before the election. And while I acknowledge that makes the resolution of this somewhat difficult, because no matter what, we have a decision coming down shortly before an election, and we have a board of elections that's waiting to know whether to deploy this equipment to this second polling place at Bard College. It would have been far more preferable to have this matter being heard 3 weeks ago. All right, Your Honors, I have about 2 minutes left, but unless there's something else, I will.
Hold that thought. Justice Chambers? Justice Ford? No? Justice Dowling? None of us? Thank you, counsel. You may be seated.
Thank you.
Next is Freibeck Law.
Yes, Your
First respondent, please go ahead, counsel.
Good morning, Your Honor. My name is Mike.
I need a little volume. Get closer to the mic, please. Thank you. If you need to move the podium or lectern closer to you, you may do so. Just don't damage it.
I'll do my
These are antiques from the 1500s.
I signed my my bar admission on this podium here, so I'm familiar, Your Honor. Good morning, Your Honors, and may it please the court. My name is Mike.
I still need more volume.
I apologize. I have to stare directly at the microphone. Good morning, Your Honors, and may it please the court.
The problem is not the podium. See, I can talk like this, but I can talk like this. I don't want you to talk like this. I want you to talk like this.
Yes, Your Honor.
Thank you.
Is that
Getting better.
Good morning, Your Honors. May it please the court. My name is Michael Freibeck, and I represent the respondent, Commissioner Hannah Black, on this appeal. Your Honors, it's not often that attorneys are compelled to advocate against the interest of their clients. In this case, however, neither commissioner would have the capacity to pursue this appeal, this particular appeal. In the court below.
So along those lines, didn't you name the Commissioner Haight as respondent in your pleadings? And why wouldn't that constitute a waiver of any challenge to his capacity and standing to appeal?
Well, Your Honor, 2 things. One, I made a cross-claim against Commissioner Haight out of an overabundance of caution, and two, it wouldn't be a waiver. Lack of capacity or lack of standing is an affirmative defense that has to be pled by the party that's defending against it. In this case, there was no such.
You can't ever waive that?
I'm sorry?
You can't waive it?
The other side can waive it. If I bring that claim and the other side doesn't object to it, then they waived it.
Can you point to where you raised the standing and capacity issue in Supreme Court?
It wasn't relevant in Supreme Court, Your Honor. Both Commissioners Haight and Commissioners Black were named as respondents by the petitioner, Bard College. In other words, they brought the proceeding against us. Within the context of that proceeding, the parties can plead, they can make motions. However, once that proceeding was over and Commissioner Haight in his individual capacity or in his capacity as one of the commissioners acting alone brought this appeal, that is an action of the board requiring unanimous consent of these two commissioners.
So along those lines, it's a little bit different focus. In the Supreme Court, the order in judgment denied Commissioner Haight's motion to dismiss. You agree?
I agree.
And in its entirety, and granted the petition that sought relief against him, right?
Well, it would have been a relief against the Board of Elections, Your Honor.
Right. So would you agree with me that the commissioner is an aggrieved party?
No, Your Honor. So
Tell me
under the Graziano v. Albany County Court of Appeals decision, they really parsed a fine line in terms of what an individual commissioner has capacity to pursue. And when it is an administrative function of the Board of Elections as a whole, that's not something that an individual commissioner can pursue. It's only when the commissioner is acting to vindicate the interest of the party that appointed them, which in the Graziano case was the constitutional and statutory requirements that the staffing levels at the Board of Elections be equal between the two parties. Unless it's pursuing that, the commissioner simply lacks capacity. Now, whether I agree with how narrowly the Graziano court construed that, I do not agree with that. That being said, that's the mandatory precedent from the Court of Appeals interpreting this situation.
But you would agree, nevertheless, that you and your adversary pursued opposing litigation through separate counsel.
Well, that is the custom, I guess. That's the practice of the Dutchess County Attorney's Office. When the commissioners agree, the county attorney's office represents the Board of Elections as a whole. When they split, the county attorney takes the position that they have a conflict, and they permit the commissioners to appoint separate counsel.
So can we shift gears a little bit, and when, from your perspective, from your view, did this cause of action accrue?
On March 16th, Your Honor.
And in your view, what did the Supreme Court determine was arbitrary?
So again, the decision of the Supreme Court could have been clearer on that point, Your Honor, and it's clear that the Supreme Court did decide, one, they denied the motion to dismiss and they reached the merits, finding that the statute of limitations had accrued on March 16th when the Board of Elections had failed to meet its statutory deadline pursuant to Election Law 4104. And there's a paragraph in there where it seems that the court is saying that what happened was that the reversion to March 19th would be arbitrary and capricious. However, in the context of the rest of the decision, that doesn't make any sense. So I would read it as saying that if the Board of Elections had adopted that position, it would have been arbitrary and capricious, as it would have, given it's in contradiction of a long-standing custom of the board. Now, in my client's opposition papers to the motion, the opposition, she does explain, and she provides the State Board of Elections guidance document, which is at Appendix 253 at the lower part of that page, which says that the boards of elections should try to relocate polling places from nursing homes, long-term care facilities, and senior living residences to minimize COVID-19 exposure, which is what they did. And that was the only exception for the poll sites that did not revert to 2020, the ones that went back to 2019, because during 2020, some of those poll sites ended up in alternate locations that were not as convenient, but because of the guidance from the State Board of Elections, they had to do that. And there was really no, they didn't, the Commissioner Haight did not object to that. He tried to provide an explanation saying, well, there's this other poll site that changed. However, he didn't explain why it changed. And it's not in the record why this other poll site changed.
Thank you.
Any other questions, Your Honors?
Any questions? Thank you.
Thank you very much.
Last but not least.
Good morning, Your Honors. May it please the Court, Michael D'Onofrio from Strisson-Maher.
One moment.
Pardon me.
One moment. One moment, counsel. Thank you for your courtesy.
Absolutely, Your Honor. Thank you. I'm Michael D'Onofrio from Strisson-Maher for the respondents, petitioners at the Supreme Court.
Please proceed.
Yes. Your Honors, in order to sort of cut through to the question of when the board's action became final, I think the best place to resolve any uncertainty is to look at the affidavits provided by the parties. Commissioner Haight at Appendix 203 he stated that the policy is to revert to the last designated polling place, and the Supreme Court correctly identified the last designated polling place for this particular polling place as the two locations designated in 2020 as a result of the agreement of the two then commissioners and as ordered by the Supreme Court. Commissioner Black confirms that understanding in her affidavit, and that's at Appendix 225. The facts themselves are beyond dispute. On February 25th, when the two commissioners moved to the discussion of Red Hook District 5, they failed to reach an agreement. Each made a motion. Each motion failed. There's no dispute that in the context of a two-person board of elections, both must agree under Election Law 3-212 in order for a motion to pass and the board to take action. That didn't happen. There was then a unilateral statement by Commissioner Haight that he believed that the poll site reverted to 2019, met with silence from Commissioner Black. On that record, the inference from silence is simply not enough to infer that the board agreed to revert back to 2019 in contravention of its policy, as stated by both commissioners in their affidavits, and that would just be too thin and too attenuated a record to charge a party with or to pick the point in time when a party's claim accrues. It would be unmanageable for parties, potentially aggrieved members of the public, to hold that burden, to infer from such an ambiguous record, okay, this is when my claim accrued, particularly in the context of a statute that very clearly gives the board this authority and this duty up until March 15th. So Judge Rosa got that decision exactly correct in terms of the statute of limitations. In her decision of October 13th, she clarified any potential confusion resulting from her September 22nd decision when she wrote, this is at Appendix 398, I apologize, my glasses keep fogging up. The court further held, beginning the quote there, that Commissioner Haight's unilateral determination that this resulted in a reversion to the 2019 polling place and to ignore the 2020 designation was arbitrary and capricious. So there she's identified it wasn't that she believed the board had done something that was arbitrary and capricious. She's saying it was his unilateral assertion of that position that was arbitrary and capricious. Your Honors, in terms of
I thought you were going to say unless the court has any questions.
If,
But I guess I might have been incorrect.
Your Honor, if I may just have 1 minute to look at my notes.
If I could ask one question, JP. So, counsel, do I understand?
Mr. Ford, allow counsel to complete his foray into the record. Thank you.
Indeed, unless the court has further questions.
Unless the court has, Justice Ford has.
Thank you.
I just have one question. So, it appears that your argument is that the court below got it right. Is that right?
Correct.
Thank you.
Any further questions? Anybody else? No? We good?
Thank you, Your
all.
Honor.
Be safe. Get home safe. All of you. Good to see you. Number 2, People versus LIDES. Lead this.